There is a motion at the desk. The chief clerk will report the motion.
Motion for the calendar for the day pursuant to Rule 1.21 and the notice given on Monday, May 4th, 2026. Hicks moves that Senate file number 3210 be placed and be considered first on the calendar for the day for Tuesday, May 12th, 2026.
I recognize the author of the motion, the member from Olmsted, Representative Hicks.
Thank you so much, Speaker. That is my motion. I would like to request a roll call.
Seeing 15 hands, there will be a roll call. Representative Hicks.
Thank you so much, Speaker. This bill has been on the General Register since March 9th. The companion passed bipartisan in the Senate, 46-18. It is a bill that expands the process of accommodations to individuals with disabilities. It should not be controversial, and there should be no reason why we can't hear it. I request a green vote.
I recognize the member from Anoka, Representative Niska.
Thank you, Mr. Speaker and members. And Representative Hicks, I appreciate your passion for disability discrimination. We're all opposed to disability discrimination. I have a younger brother who is legally blind and has benefited from a lot of disability protections. I remain puzzled by the drafting of this bill. The same questions that I think weren't really answered in the one committee stop it did pass. It either doesn't do anything or it does something that no one has really been willing to explain what it does. So the motion before us is to calendar it without a pre-filing requirement. So if the author will yield for a question.
Representative Hicks will yield. Representative Niska.
Thank you, Mr. Speaker. Representative Hicks, do you plan to offer an author's amendment to this bill, or are you going to ask us to vote on the bill as it was sent by the Senate?
Representative Hicks.
I plan to ask us to vote on it as it is currently presented from the Senate.
Representative Niska.
Thank you, Mr. Speaker and Representative Hicks. Then I do have a series of questions that I don't think were answered in committee and have not been answered to how this, in your words, expands the process. If Representative Hicks will yield to another question.
She will yield. Representative Niska.
Thank you, Representative Hicks. So the language in this bill says failure to engage in the process to determine an accommodation. What is the process to determine an accommodation referenced in the language you're proposing to add to the Human Rights Act?
Representative Hicks.
Thank you for the question. The process would be determined by the employer and would need to be made available upon request.
Representative Niska.
Thank you, Madam Speaker and or Mr. Speaker and Representative Hicks. Is the process in relation to employment different than the process that's already in subdivision 363 or section 363A.08?
Representative Hicks will continue to yield. Representative Hicks.
The process would be outlined based on what's currently in statute, but it, as the language is currently written, would give an opportunity to ensure that that process is equally followed by the person and the entity to which they are negotiating accommodations.
Representative Niska.
Thank you, Mr. Speaker and Representative Hicks. Is the process, so your bill references the process in employment, housing and real property, public accommodations, public service, and education. Is the process referenced in line 2.6 the same or different in each one of those areas?
Representative Hicks will continue to yield. Representative Hicks.
Just like all accommodations processes, it would be based on the individual needs of the person requesting accommodations, which is the purpose of this bill, is to ensure that those things can happen. And although I absolutely respect Representative Niska's line of questioning, this feels like the debate we should be having tomorrow, not the conversation about whether a bill that's been on the General Register since 3/9 and has passed the Senate 46-18 should come to the floor. I would love to have this conversation first thing tomorrow.
Representative Niska.
Thank you, Mr. Speaker, and appreciate that, Representative Hicks, that you want this bill calendared. Unfortunately, it hasn't really had the committee work that it needs in order to do that. In line 2.8, it says that failure to engage in the process to determine an accommodation in 2.8 says may be a unfair discriminatory practice under this chapter. In what circumstances would failure to engage in the process not be an unfair discriminatory practice under this chapter?
Thank you, Representative Niska, for the question. Again,
Representative Hicks.
oh, sorry, Speaker. Again, it says may to allow for the ability for this to be an interactive dual process between people with disabilities and the entities that they are requesting accommodations for. And I would again remind you, we are not debating the bill. We are currently just debating whether or not people with disabilities who came and said, hey, this process isn't really working for us, we think this would be helpful, can have a full floor debate on this bill tomorrow. I appreciate that you do not want to hear this bill. I understand that it is something that you are not interested in hearing. My motion today is to hear it. If you don't want to hear it, just vote no.
Representative Niska.
Thank you, Mr. Speaker, and appreciate your advice, Representative Hicks. The concern I have is that I think your addition of the word may actually waters down the disability discrimination that we currently have under Minnesota law, in particular in the employment context, because it says that there are situations where failure to engage in the interactive process would not be an unfair discriminatory practice under this chapter. And so it's introducing ambiguity into the law. You said you did not plan to offer an author's amendment. So I think this actually harms the current ways that we have defined what accommodations mean and how the process to determine those accommodations happen. So I would like you to direct because the only thing you do is amend the policy section. You don't actually amend any of the operative section. So if you have the operative language in front of you, I would encourage you to turn to 363A.08, specifically subdivision 6 in the reasonable accommodation section, which says, among other things, quote, reasonable accommodation means steps must be taken to accommodate the known physical or mental limitations of a qualified individual with a disability. To determine the appropriate reasonable accommodation, the employer, agency, or organization shall initiate an informal interactive process with the individual with a disability in need of an accommodation. So if Representative Hicks would yield to another question.
She will yield. Representative Niska.
Thank you, Mr. Speaker, and Representative Hicks. How does your language that says failure to engage in the process to determine an accommodation may be an unfair discriminatory practice change the language or the meaning of 363A.08 subdivision 6?
Representative Hicks.
Thank you so much for the question. So again, the language that you're referencing is about reasonable accommodations. This language is about the process of reasonable accommodations. And although I absolutely respect your opinion and understand that you're an employment lawyer, the Disability Law Center has stated and has provided testimony that this would strengthen. The Minnesota Department of Human Rights is comfortable with this language, and most importantly, people with disabilities have asked for it. And I know that sometimes in this place it can get a little technical, and we can sometimes be very focused on this to that and this and procedural and all of those things, and that's super appropriate. But in this instance, people have said, this will help me. The Minnesota Disability Law Center has said, this will help people with disabilities. The Minnesota Council on Disabilities has said, this will help people with disabilities. People with disabilities have said, this will help me. And one of the reasons that I'm not offering any amendments is, as I've stated, I think 3 times now, this has already passed off the Senate floor. And so I would like to avoid a conference committee and get this into law. And I would, again, request the leader, Niska, consider the fact that the vote today is not the bill debate. The vote today is to put it on the calendar for tomorrow. And I welcome further conversation tomorrow when we hear this bill on the floor.
Representative Niska.
Thank you, Mr. Speaker and Representative Hicks. I will give you one more chance at this question because I think you maybe misheard the language that I read to you. You said that the language in 363.08 subdivision 6 refers only to the accommodation itself and not to the process. So I just want to direct your language, your attention again to the following sentence in 363A subdivision 6. To determine the appropriate reasonable accommodation, the employer, agency, or organization shall initiate an informal interactive process with the individual with a disability in need of the accommodation. And Representative Hicks, if she will yield for another question.
She will continue to yield. Representative Niska.
Thank you, Mr. Speaker and Representative Hicks. My question is, this language says shall, your language says may about the interactive process. So I'm trying to understand how your bill would change the meaning of this language here about the interactive process that mandates the employer to use the interactive process.
Representative Hicks.
Thank you so much again. It doesn't, because that's not the section of law that it's in. What this says is that failure to engage in that process may be considered discriminatory. And again, the Disability Law Center says this would be helpful. People with disabilities say this would be helpful. The most frequent group of people who go to the Minnesota Department of Human Rights are people with disability complaints. We are trying to solve a problem, and those folks have said this is the solution. And if you do not agree that this is not the solution, then tomorrow, when we hear it on the floor, vote no.
Representative Niska.
Thank you, Mr. Speaker. And Representative Hicks, I heard you say that this doesn't change that. I think that's actually probably false. I think this, if anything, creates some ambiguity that might give employers off the hook for not doing the interactive process, which is the exact opposite of what you said this bill does. The fundamental problem is this is introducing ambiguity to the clearly, much more clear prescriptive parts of the Minnesota Human Rights Act. I think it does it again in 363A.10, which is defining reasonable accommodations in the area of real property or disability discrimination. So, Mr. Speaker, if Representative Hicks would yield to another question.
She will yield to another question. Representative Niska.
Thank you, Mr. Speaker and Representative Hicks. How does your bill affect the meaning of 363A.10, real property disability discrimination?
Point of order, Mr.
Hicks,
Speaker.
State your point of order.
Mason's 101, we've allowed a lot of leeway, but Representative Hicks is right. The subject of the debate is not the bill itself. The subject of the debate is the motion to calendar this for tomorrow.
Representative Niska.
The bill before us does the exact opposite of what the author of the bill just represented before, that it expands the process. She said it's not controversial. It's a poorly drafted bill. I'm sorry. It's not ready. It needs more committee work. It likely needs to go to the Housing Committee if it changes the meaning of housing discrimination. It likely needs to go to the Education Committee if it changes the meaning of public services and education provision, 363A.12, 363A.13. Representative Hicks will yield to a question.
She will not yield. Representative Niska.
What are we even doing here? The 363A.13 says it's an unfair discriminatory practice to discriminate in any manner in the full utilization or benefit of our educational institution on the basis of disability discrimination. The author of the bill won't tell us how it affects that. The author of the bill won't tell us how it affects any of the actual operative provisions of the Minnesota Human Rights Act. I understand vibes. I understand being opposed to disability discrimination, but what we're doing here is we're making law. And this bill that's before us is not a good law. That's why the questions that were asked in Judiciary Committee were not appropriately answered. Tomorrow, we can take this up with no pre-filing requirement. I think there will actually be very little discussion about this bill and probably a lot of discussion about other provisions of the Minnesota Human Rights Act. I think that'd be a lot of fun, but I don't think that would be a productive use of our time in this session with a very poorly drafted bill before us. It shouldn't be calendared. Members vote no.
I recognize a member from Hennepin, Representative Coulter.
Thank you, Speaker. Mr. Speaker, would Representative Rapinski yield for a question?
Representative Rapinski, will you yield for a question? He will yield. Representative Coulter.
Thank you, Mr. Speaker. So, Representative Rapinski, I see you became a co-author of this bill on March 12th, after the bill got its second reading on March 9th. Do you agree with your floor leader's assertion that this bill is poorly drafted and should not be calendared?
Representative Rapinski.
Thank you for that question. I feel the same way that Representative Niska just explained my concerns with that bill. And I'm a big supporter of mental health and those sorts of issues. That's why I was originally on the bill, but I do have some concerns with it.
Representative Coulter.
Thank you, Mr. Speaker. Well, again, to correct the record, Representative Rapinski became an author of the bill on March 12th, after the bill was given its second reading on March 9th. I don't know that that qualifies someone as an original author. Mr. Speaker, would Representative Nadeau yield for a question?
Representative Nadeau is not sitting at his desk currently, so I am assuming no.
Oh, that's too bad.
I recognize a member from Ramsey, Representative Finke.
Thank you, Mr. Speaker, and thank you to, I want to thank Representative Hicks for your bill, and I do want to thank Representative Niska for his line of questioning, because as it happens, we had this exact line of questioning in judiciary, and we had members of the other side who were pretty convinced of the argument that you were making, and we had an opportunity in judiciary to explain why that line of argument doesn't hold up, and then the bill moved forward. You are confusing. I mean, look, it's hard. This is hard work. And the fact of the matter is not a lot of people actually know what the process of getting workplace accommodations for people with disabilities entails. And this bill is not about whether or not a workplace can provide accommodations to their employees with disability. You're right. They must provide agreed upon accommodations to their employees. That's not in question. What's in question is, do they have to negotiate in good faith about those accommodations? Do they have to accommodate people in the process of accommodation? And I know that people kind of have this idea who is like, well, you have a person who has disabilities and they've requested accommodations. Of course they get them, and then if you don't provide them, you're breaking the law. But that is not at all what the process of getting your accommodations met is like. And if you live with or love people who have many disabilities, you will know, for example, 75% of accommodations requests are denied by employers. And this is about those 75% that are denied. They don't have to provide them. There is no requirement in the law that your accommodations are provided. The law says if you agree upon those accommodations, then they must be provided. But talk to anyone who has to work in a workplace that is not suitable to their living condition, and they will tell you almost all of their accommodations are denied. And what this bill is looking to do, Representative Niska, is say there has to be more protections for people who have disabilities in the process of negotiating their accommodations. Because the power differential between an HR department and a person who is seeking accommodations is monumental. Absolutely monumental. And if you cannot even engage in a good faith accommodation negotiation, that is the process that needs the protection. That is the reason people with disabilities are coming out day after day after day to say we need help in our achieving accommodations. It is not a question of whether or not accommodations are provided. It is getting the accommodations in the first place, a torturous process for so many people in the workplace and many other places. That is what we're talking about. It is separate from what you were talking about. And the process itself needs the protections. The process of that negotiation for the party of that negotiation that is the employer needs to be protected. It's a very different problem and process. Second, I do want to address what Representative Niska just said about whether or not this bill comes to the floor tomorrow, and we have no pre-filing amendment, and we have a debate about the Human Rights Act. And I just want you to know that we're not going to back down from a fight about my community because you want to keep the rights of people with disabilities out of the Human Rights Act. That sounds fun to you? You think it sounds fun to drop amendment after amendment after amendment attacking vulnerable communities in the Minnesota Human Rights Act? Go ahead and do it. We will fight for the rights of all Minnesotans, and we will not allow certain communities to be weaponized against the rights of others. That's disgraceful and disgusting, and if you enjoy it, that's fine. Have fun. We will fight for the rights of our people.
I recognize the member from Anoka, Representative Engen.
Thank you, Mr. Speaker. I want to reground us about what conversation is occurring right now. It's whether or not to have a bill calendared that allows for accommodations for people with disabilities. This isn't about fighting for our community or making this about ourselves. It's about allowing those amongst us who do face struggles and challenges and sometimes disparities from having the opportunity to engage in a discussion. That's what we're talking about here. I'll be voting in support of this despite my understanding as to why we wouldn't. I think there are some questions that I still have yet to be answered. That's fine. We can ask those questions tomorrow. But this brings me to a personal experience at a job that I had during college. It was J-term, and I was working at a bicycle tool company. It was 10-hour days, long days of absolutely monotonous work that would drive anybody to insanity. But one of the best parts about the job is I got to see Josh. And Josh came from a day provider called Merrick, and he was referred to this company after demonstrating a real interest in bicycling, and so it kind of fit perfectly. And at first, Josh was not very comfortable at the workplace setting. He was cutting up cardboard and removing staples before putting that cardboard into a shredder and tidying up, making sure the trashes were taken out. And we ended up having a really great relationship, and I still talk with Josh today. And he went and asked for reasonable accommodations so that he didn't have to try to show up to work when his busing and transportation was out for a weather-related issue. In the middle of a snowstorm, he doesn't have his Met mobility to get him to work, so those accommodations were met. He wanted to know if there were sometimes days that he could put in his headphones or earplugs so that he could just have a little bit more peace than maybe the job provided. There were times where he simply just needed to take an extra 15 minutes because in his head, things were getting a little too chaotic, and I've been there. I got a 2-year-old at home. I'm there all the time. So all of those accommodations were met, and they were met with grace. And why I'm proud of that is because the guy who granted that accommodation was my dad. My dad was the GM of this place, but he loved having the conversation with Josh, and he ended up taking Josh to Twins baseball games that I attended alongside him. I mean, this was years ago, but it's an accommodation, and it's a discussion that I think is worthy of being had. I just want to say, let's reground ourselves about what we're doing here. What are we actually engaging in, and what dialogue are we bringing to the discussion that either helps advance the goals that we're trying to achieve, and for who, or are we making this about ourselves and throwing mud when we otherwise don't have to. So, thank you.
I recognize a member from Hennepin, Representative Kraft.
Thank you, Mr. Speaker. Members, I also want to kind of back up a little bit. There's been an incredible amount of discussion of very detailed things on this bill, most of which I do not understand. But the question that we're being asked is, do we calendar a bipartisan bill that has been on the General Register for 2 months, almost 2 months? And there was a comment made that it needs more committee work. Representative Niska, Leader Niska, that's not your call to make. It has been through committees. It has passed through committees. It sounds like unanimously. It's on the floor. I have to agree, like it became almost badgering to me of Representative Hicks on getting into the detail of this bill. Let's have that discussion tomorrow. This is a bipartisan bill. It's been there for a couple months. We can have this debate, and I also do resent the implied threats of it's going to have other amendments on it. Let's just do the work. It's a bipartisan bill. Let's do this.
I recognize a member from Ramsey, Representative Lugar-Nicolai.
Thank you, Mr. Speaker. I rise in support of Representative Hicks' motion. I think this is an excellent bill. I think it is a bill that we should calendar today and we should pass tomorrow. This bill makes changes to the public policy section of 363A, the Minnesota Human Rights Act. So importantly, it doesn't make changes to 363A.08, which is the parts of the law that refer to employment. That, as Leader Niska noted, already contains a requirement that individuals, employers, engage in the interactive process. Now, it does refer to other parts of the statute, however, including the prohibition on discrimination with respect to housing and real property, public accommodations, public services, and education. Those you can find in subsequent parts of the statute that I will not name because it makes terrible video. However, those are all parts that themselves do not contain language regarding the interactive process. I looked, I double-checked, I used Control F several times. And so this is an important change, especially for those provisions, but more importantly because this directs the policy orientation of the department. It is the public policy section of the statute. It is the poll star for how the department is to interpret and enforce the law. And so it is important that we make these changes to ensure that individuals who are seeking public accommodations, seeking housing, seeking equal access to education know that when they are in a situation in which they may need accommodations, there is going to be a requirement that they are met halfway or partway or in any way necessary for them to get what they need, because as a society, we all agree that that's important. So we should calendar this bill. We should pass this bill. It is good language, and it will not take us backward. It will only take the department forward. Thank you.
I recognize the member from Ramsey, Representative Curran.
Thank you, Speaker, and thank you for the motion, Representative Hicks. This is something that is a long time coming. I'm quite dismayed by most of the conversation that's happened today, but I am glad to hear it sounds like we'll have support to get this calendared. As we head into our discussion on the meat of the very short bill tomorrow, I want to remind everybody that there was a roll call on this in the Judiciary Committee. Every single member who was present, that was everybody except for one excused member, voted in favor of this bill. And what this truly is about is people with disabilities being given the right or ensured the right that their employer will have a conversation with them. That's what it does. It's not difficult to understand, even though I know there was some legal words thrown around like absolutely probably not true. I think that was a pretty legal thing you could stand by. Absolutely probably not. Sure. As we go into this discussion tomorrow, folks, this is a serious, serious issue that Minnesotans who are extremely vulnerable face. Some we can see on their face or through their body movements. Some are invisible. There are people in this very room with such invisible disabilities. And I just want to encourage everybody to please approach the conversation that we are about to have tomorrow with the due respect that it deserves for the disability community. It is about nothing more and nothing less than supporting our neighbors with disabilities, and I hope we can hold to that. Thank you.
I recognize a member from Anoka, Representative Niska.
Thank you, Mr. Speaker and members. And I do want to ground us in what we're doing here, which is we're trying to make law. We're trying to add clarity to statute, not ambiguity to statute. And the problem that I have with this bill, and the reason why it actually should go to a number of committee stops or else there's no point in passing it, is that it either doesn't do anything or it does things that we don't know and nobody's really being honest about what it does. So Representative Finke said that what's in question is whether you have to negotiate about the accommodations and that there's no current requirement to provide accommodations. Actually, in the employment context, there is a very clear requirement to have a process to go through to provide those accommodations. And this bill actually creates ambiguity in an area where there currently is certainty. But in other places where that clear, reasonable accommodation interactive process is not in the statute, apparently Representative Lugar-Nicolai thinks that now this is creating new statutory language in those other sections, but nobody has bothered to actually bring a bill that amends 363A.10 relating to real property, or 363A.11 relating to public accommodation, or 363A.12 related to public services, or 363A.13 related to educational institutions. Those are the operative statutes where somebody looking at trying to understand how to comply with the Minnesota Human Rights Act, a company, a school, a government agency, they should be looking to those, they should be able to look to those provisions to understand what is the process that needs to happen. Our housing providers should have an opportunity to look at that language and provide input into whether or not that's workable in the Housing Committee. Our schools should have an opportunity to look at the language about what an interactive process would be in the educational context and provide input within the Education Committee. None of that has happened because instead of actually amending the operative language and providing clarity, what we have in front of us is an amendment to the public policy section that actually creates more ambiguity. I appreciate that there are disability lawyers and other lawyers who would love this bill to pass because it creates a lot more work for lawyers and judges to figure out what is it that the Minnesota Human Rights Act means after this. I fear for workers, disabled workers, that we're actually undercutting their protections. I fear for schools, for housing providers, that we are putting a litigation target on them without giving them guidance about what they need to do in order to do that. And I would remind the body that the Minnesota legislature did actually really foul up the Minnesotans with Disabilities Act and had to go back through and amend a lot of the litigation provisions because a guy named Paul Hansmeier, who then ended up in jail, did a lot of hit and run shakedown litigation because the Minnesota legislature amended the Minnesota Human Rights Act disability provisions without having thought it through carefully. So, Mr. Speaker, members, this bill is not a bill that is ready to be passed into law. It either doesn't do anything, it either doesn't change the law at all, or it changes the law in unpredictable, uncertain ways, that is not our job as the Minnesota legislature. We should be providing clarity. This bill provides ambiguity and uncertainty. It undercuts disability protections in some areas. It perhaps creates unintended consequences in other areas. This is not a good use of our time to take up this bill and to open up a Wild West style amendment possibility into the Minnesota Human Rights Act. We have other important work to do. This is not the thing that we should be spending our time with tomorrow. Members, vote no.
I recognize the member from Olmsted, the maker of the motion, Representative Hicks.
Thank you so much, Speaker. And I will just say, I disagree that passing a bill to extend the rights of people with disabilities when they have specifically come and asked for it is absolutely a good use of our time. Because it has passed the Senate, and so it will be, I believe, good law if we pass it tomorrow. I also think the statement that it will be the Wild West and not a good use of our time is a choice. It doesn't have to be the Wild West. We can choose, collective we and individuals can choose not to file amendments that aren't about disability. That's a choice. It's not one I'm confident people will make, given the things that have been said, but it is a choice. And if it truly does nothing, then I don't understand why the Disability Law Center and why people with disabilities and why the department have said it does nothing. That's not what they've said. They've said it would be helpful. And if it does something, the something is protecting people with disabilities against discrimination. And if that's not what we're here to do, and that's not bipartisan, and we don't believe in that, then I guess we can vote no tomorrow. But I do believe in it, and I think we should have the conversation. And I would appreciate a green vote so we can do that.
Seeing no further discussion, the clerk will take the roll. The clerk will call the names of the members voting remotely.
Jones.
Jones, aye.
Jones votes aye. Momani Hilsley.
Momani Hilsley, aye.
Momani Hilsley votes aye.
The clerk will close the roll. There being 68 yeas and 57 nays, the motion prevails.